Hi, everybody. This is Attorney Maria Baylor of the law firm of Samuel, Sayward, and Baylor, located in Dedham, Massachusetts, where we focus our practice in the areas of estate planning, elder law, and estate and trust administration. Welcome to this week's edition of Smart Counsel for Lunch. This week, we have one of our Smart Counsel interviews, and today's guest is Attorney Barbara Nason, who's a family law attorney, a mediator, and a collaborative attorney who presently is of counsel to the law firm of Tracy, Roman, and Ramus in Wellesley. Barbara, welcome.
Thank you.
Thanks for being here. Why don't you tell us a little bit more about yourself?
Thanks, Maria. Thank you for having me. So I am currently, my practices, I've been practicing for over 30 years, and I primarily today now do divorce mediation and primarily drafting prenups and postnuptial agreements is what I primarily do now, and some collaborative work. Formerly, I was a divorce litigator, and I happily am no longer doing that type of work anymore, and most of my referrals are from divorce litigators, but I am not doing that court work anymore and happily doing divorce mediation, which is a booming business these days.
Yes, I'm sure that's a much more pleasant way to resolve those kinds of things if both parties are in agreement with that.
Yes.
So today we're going to talk a little bit about the intersection of family law and estate planning. You might not think that divorce attorneys and estate planning attorneys talk a lot or have a lot in common, but in fact we do, because on the estate planning side, we hear a lot about parents, concerned that assets are going to leave their children, be protected in the event of a divorce. We've all heard the statistics, Barbara, about how many marriages end in divorce, which is good business for you, I'm sure, but is a concern. And on the family law side, like as you mentioned, prenups and postnups intersect with estate planning quite a bit. So
Yes.
let's dive into that and talk about a few topics where we cross over. Let's talk about prenuptial agreements first. Those are a really popular topic for people to want to understand better how they can help their family and protect assets. So let's talk first about young couples, right? You're 30 years old, you've just started working, you might not have a whole lot of assets, and your parents are saying to you, maybe you should think about getting a prenup before you get married. So if you're a young couple and you don't have a lot of assets, do you need a prenup?
So that's a really great question, Maria. So it's funny, I think sometimes, I'll just back up a little bit and say sometimes young couples think they don't need one because they don't have anything. So it's even before the parents get involved, they think they don't need one
Right.
at all because they don't have anything. One, they don't want to think about it at all because they're in the crux of getting married and the excitement of it. But secondly, they're like, we don't have anything, we don't need it. So the first reason you might want one, it is a great way to do financial planning and to think about how you want to think about your financial future. And I don't think people think about that enough. A lot of couples these days that are young couples, it's unlike the traditional way where you just pull all your money into all joint bank accounts and everything's held jointly. A lot of couples these days do everything separately. They have separate bank accounts. They might have one joint bank account, but they do everything separately. And the assumption is, for a lot of couples, I see it now today, is if they get divorced, they think everything that's in their own name is theirs. Whereas, quite frankly, everything is, whether it's in separate names or not, it's all joint. It's all joint marital. It all goes in the pot and it's all divided. And sometimes people are very surprised by that, when in fact, doing a prenup can actually, again, no one wants to think about divorce when they're getting married, but thinking about how they might want to divide things, and even though they don't know what's going to occur in the future, they don't know if they're going to have businesses or how their assets are going to accumulate, thinking about that and thinking about how they might want to divide things. Is it going to be all joint? Is it going to be separate? Are they always going to keep things separate? Or are some things going to be joint? Are ways to think about how they want to do things in the future.
Yeah, good idea. And even if one of them might come in with some more assets than the other one, that's a different situation where it's even more important, right?
Right, right. And how does that play out down the road? If they have children, what if one of them's not working for a while? how does that all play out? So thinking about those things, even having the conversation, if it doesn't end up in a prenup, is not a bad thing
I
to
was
do.
just thinking about that. Those are things you should talk about anyway before you get
Right,
married, right?
right.
So very good. Okay,
Biggest
so
one,
now,
right. The biggest
now,
one I see, I was just going to say, is
mm,
the inheritance piece, right?
yes.
And
So that's
that's
where
when
the
the
parents
parents,
come in.
right, exactly. And sometimes I find that parents will even come to me and say, well, I have this phenomenal estate plan. There's a spendthrift clause, and my attorney says that there's no way that my son or daughter's spouse can touch it. There's no way, right? They said, well, let's think about that for a second, because that's not quite true, not in
Mm,
Massachusetts. Okay. So, and the reason I say that is because if there is no prenup, and your child gets divorced down the road at some point, right? Whether they've been married for 5 years or 20 years or something like that, right? A court, even if they can't touch that inheritance, right? A court can consider it and consider how much that inheritance is when they're dividing the actual marital estate of the parties, of the
yeah.
child. So they can then they can divide the estate instead of it maybe being an equitable or equal division. They could make it go like this, maybe in favor of what I might call the spouse that is not inheriting the funds, right? So, so that actually can change the division.
Because the court is considering this trust that the child has, right? And
Correct.
if they
That's
have the benefit of, even if they don't have control over it.
right. Now, the way to prevent that is to have a prenup. So if you have a prenup that says inheritances cannot be considered, whether they come in during the marriage or whether they have not yet come in, if at all, right?
Mhm.
And they cannot be considered in that division.
Yeah,
So
that's a really important point, right? Even if your trust is great and protective, the prenup
correct,
gives you that
correct.
extra
And
protection.
so doing that is super important. And why a lot of people who, kids who get married who don't have any money, just having that clause that says that inheritance can't be considered in divorce is really, really important.
So if I'm a parent and you are preparing a prenup for my child,
Yes.
what do I need to know about what information I might have to share?
Yes, that's an excellent question and something that I encounter very often.
Mm,
So there are lots of things that make a prenuptial agreement enforceable. And I'm not going to go into that now because that is a different series, right? Or different seminar. But one of the and that's a long one, so we won't go into that now.
yeah.
But one of the more important ones, and one of a super important element to make that prenuptial agreement enforceable, is full financial disclosure. And part of that full financial disclosure is that you must list what the potential inheritance might be, which means that you have to have an awkward conversation with your parent that says, I need to list what my potential inheritance might be. So mom, dad, I need to know, what do you have? Now, of course, the parents go, well, now, in a couple cases, right, you might actually know what your parents have, or your parents might be saying, sure, and you have an open conversation about what there actually is. But there are often many times where parents don't really discuss all of their exact finances with their children,
Right,
and what do they want your children to know?
right.
So this becomes an awkward, uncomfortable conversation, and
Mm,
sometimes an angry conversation because they're blaming the other person for it, when in fact, it's really their own attorney. Maria, you're the parent, right? I'm the
yeah.
attorney saying, Maria, I need to have, I'm your child's attorney, and I'm saying, I need to know exactly what you have. I'm sorry, but I have to.
Yeah, and I'm saying, I don't want to tell you because if my child finds out they're inheriting $5 million, they're going to quit their job tomorrow and go lay on a beach for the rest
Right,
of their lives.
right. And I'm going to tell you, well, if you want to make sure that your $5 million does not get in the hands of your child's spouse down the road in some manner, or that if they get divorced in some way,
Mhm.
and your child doesn't lose out on their fair share of the marital assets, you need to tell me a good idea of what you have and what that $5 million consists of, because otherwise that prenup agreement may not be enforceable down the road, and it's not worth the paper that it's written on.
Yeah. So
So,
it's an important thing for parents to know going in, and the whole family to know going in, right? To make this enforceable, you have to have this disclosure, and if you're not willing to do that, then
right. And it's touchy. It's very touchy.
yeah.
And I've had, I've had only really on one instance did I have somebody that just said, we're not doing it all because I refuse to share that information with my child.
Yeah,
But they usually understand that afterwards, but it is very important that information is shared on both sides.
right,
So, but on both sides, yet usually it's the person that's really wants, the reason you are trying to protect that inheritance means you have to share it. Now, the other thing I hear very often is, yeah, but maybe by the time, if they get divorced, 20 years from now, that money's going to be gone, or 15 years, that money's probably going to be gone. It's going to be used for my care. I might spend it. I might disinherit, which
right.
is also could be true. But it's important to share what there is now at the time of the signing of the prenuptial agreement.
Yeah, just to make sure it's gonna work the way you want it to, right?
Right.
All right, so let's moving along chronologically. You're married and then things don't start going so well. So
Right.
you're now in the process of getting a divorce. What do you need to know if someone files for divorce in terms of what you can and can't do about your estate plan? Because if I file for divorce, I might say, okay, well, I got to make sure if something happens to me during this process, my spouse isn't getting anything. I'm going to change everything. I'm going to move my money. I'm going to, people want to react, right, to this event. So
Right.
is that possible?
So the first thing everyone needs to know is once a complaint for divorce is filed, there's an automatic restraining order on assets. So that's the first thing you need to know, is that there's certain things that you cannot do and change. Like the first thing that seems that everybody wants to do is change the beneficiary on their life insurance policies. And that is something you cannot do. And some people do, and then they have to change it back.
Mm,
So until it's completely agreed upon in your full agreement, or there's a divorce judgment, the life insurance policy, that the beneficiaries need to stay the same. You cannot, although most of the time you cannot, because the retirement, the beneficiaries on retirement accounts cannot be changed. Usually if you're married, you can't change them anyway, unless the spouse agrees.
yeah, that's a 401k. On IRAs, it might be different, but still, you're not allowed to do it because of this automatic restraining
Right.
order.
You also cannot withdraw funds from investment accounts, retirement accounts, unless you're already using the funds for, ordinary household expenses and payment of bills and things like that. But typically, if you have counsel, there's going to be an agreement on what you can and cannot withdraw. Otherwise, there's a restraining order on all assets. So you can use money for payment of bills, attorney fees, but other than that, you cannot move funds, you can't sell property, you can't do any of those types of things once the divorce is filed.
How about your estate plan? Can you update your estate plan to, cut out your soon-to-be ex-spouse?
Well, so this is the interesting piece. You can't do any of those things, although people do it all the time, right? You can change like your healthcare proxy, your durable power of attorney, all those things you can change.
Mhm.
What will happen though is, so for instance, people will all of a sudden, parents all of a sudden change their will, people change their wills all the time. However, the court will say that that's not going to be, that's a no-no. That's a big no-no. Now, what I do advise people is that, because people think that their will or all these types of things will be good. And I know we haven't gotten to what happens post-divorce, right? But they should start thinking about what they're going to change post-divorce.
Mhm.
So
When they can.
people start changing. A lot of couples, because they come to me for mediation, say, well, we want to change ours now. And you can start making changes. You just can't make them effective until after the divorce.
Got it.
Right?
So you make a good distinction between powers of attorney and healthcare proxies, which just appoint decision makers if you get sick to handle your financial matters or your healthcare decisions. That does not relate to the ownership of assets or
Right.
changing how assets would go if you passed away. So those are different than actually changing a will or changing a trust that's going to distribute assets in a different way that
Right.
maybe hasn't been agreed upon yet, right? So you have
Right.
to kind of wait and see on those.
Right. Especially like if there are trusts and all of a sudden you're changing like the beneficiaries of trusts or things like that, that are not irrevocable, that are revocable and things
Yeah.
like that. That's going to tip the court off that, that things are not quite right.
Right.
So,
Okay, so let's move along to now you are divorced, or at least you've signed your separation agreement.
Right.
What does that mean in terms of your estate plan and the timing of things?
So your estate plan, you know, I always tell people you could start doing, a lot of people think that they should go to the same estate plan, you know, estate planner, and redo everything together, right? But as you know, Maria, you would have to get them to sign a waiver, a
Yes.
conflict waiver, right?
Yes.
So some people, I always tell people they can go to their own person. They can still go to the same person, but they're going to have to sign a conflict waiver, right?
Yep.
But then people can each do what they want at that point, once they've divided their assets and they're divorced. A lot of people still think in their head that they have to do it together after they're divorced, which is always very interesting.
Yeah.
But they can do what they want with their own assets to a certain extent. But here's the thing, they can start doing it prior to the divorce, but they cannot sign it until the divorce becomes final.
Got it. And so when is that, Barbara? Is that when you sign your separation agreement?
No. So once they sign their separation agreement, it gets submitted to the court and a hearing is assigned. So basically they go to the hearing. So it depends on whether it's a contested divorce or an uncontested divorce. So the timing is slightly different, and I'm going to confuse all of our viewers if I tell them, but let's just say that once the entry of the judgment of divorce nisi, which is NISI, once that is entered, which is technically your final divorce for the purposes of this discussion. That is when, after that enters, that is when they can then sign their new estate planning documents.
Okay, and that's sometime after the separation agreement is signed and after the hearing.
And after the court hearing.
Okay, so once that happens, the law takes matters into its own hands, essentially. And the law says if you are divorced, it used to be a divorce revokes your will entirely. Now it doesn't. The law says a divorce treats your estate plan as if your ex-spouse had predeceased you. So essentially it removes your ex-spouse as the personal representative of your will, the trustee of your trust, a beneficiary in these documents. Right. And some would say that seems to make sense, but oftentimes if you remove people from documents in that way, when they're not actually dead, but just presumed to be dead, the plan may not make sense, or the people you've named as the successors to your spouse may not be the people you want anymore. You know, maybe it was your sister-in-law and now you're divorced from her sister and you don't really want that person to be your personal representative anymore. So it really is important to review and update your plan at that point and make sure it's all making sense. And the other thing is making sure it's consistent with whatever your separation agreement might say in terms of your assets, right?
Correct. And also very often people are required to keep life insurance. Like that's just another piece to it too. They're required to keep life insurance for security purposes, for either alimony or child support. Right. And so that particular policy may be required in order to secure those things. But at the same time, you might be using that life insurance policy for something else in your estate plan, or, you know, you just have to make sure that everything is consistent and not inconsistent with what the estate plan that you have. And so therefore, it's super important that once you get divorced, that you then meet with your estate planner and then make sure that they have a copy of the separation agreement so that everything matches up.
Right.
And
absolutely.
People have a tendency, because one, everything is costly and they have a tendency to kind of put it off, but that if something happens in between, that's problematic.
Yes.
So, right. So that's one thing that's really, really important, should really be done in conjunction.
Right. And like you said before, Barbara, if we've represented a married couple together for planning, we cannot represent them after they get divorced unless they agree. So unless the husband agrees, I can still work with the wife, or the wife agrees, I can still work with the husband. In that case, we could work with them both individually. We could work with one and not the other. We could work with neither, but there has to be a waiver of that conflict before we can do that. Okay. So if you have been married and divorced, and now you're lucky enough to find love again, and you're thinking of getting remarried, we're back to the prenuptial agreement discussion we had at the top. But prenups for people who are in a second marriage are very different than a prenup you would do for a young couple that's getting married for the first time, right?
Right. And even more importantly, I
Mm.
think a prenup in second marriages are super important. Sadly, I hate to say it, but the statistics of divorces in second marriages are probably even higher than first, which I don't know why, but they are. But second, now you're really bringing in assets, probably both parties to the marriage. And very often, not always, but very often you have children and assets from a prior marriage. So it's super important that, things are done thoughtfully. You don't want to be married for even if it's a shorter term marriage on the second end, and then have everything go into the pot when you've accumulated for so many years.
Right.
And hopefully it's not just a couple of years, but you just don't know. And so it's really important that you think of these things. In addition to that, one of the things that's important to think about is the estate planning piece, right? So very often prenuptial agreements, sometimes they provide for how, some of the assets may be accounted for in the event of a death of a party, or sometimes they just put a waiver in, right? That just says, however the estate planning, how, what I'm trying to say here, Maria.
Yeah, that the spouse doesn't have any right to contest the estate plan or to,
Right.
elect to receive whatever the statutes would give them. The estate plan stands on its own, and whatever each party chooses to do,
Correct.
they can do.
Correct. But there are times when people put things in their estate plan, like for instance, they might say, in the event of my death, my second spouse will receive the house, or will have the right to remain in the house for 3 years, and then it will go to my children, or things like that. And so it's really important if the prenuptial agreement says something like that, which sometimes it can, that the estate plan that's in existence also matches that.
Right.
I had a case one time where it said exactly that, and then they did not update the estate plan to say the same thing. And sadly, the husband passed away in between, the time, and it allowed for the wife to stay in the home for 3 years, but the estate plan didn't say that. It just said the house is left to the children. And then unfortunately, there was a big problem between the children getting the home and the second wife. The prenup said that she could stay in the home, and so they eventually worked things out, but it took a long time, and court actions and a lot of messiness.
Yeah, and a lot of money. Yeah.
And a lot of money. So it really, really makes sense, that everything matches up, right?
Yeah, and you hope people will, you hope family members will do the right thing, but you can't count on that. And the documents, assets are controlled by ownership and state law or your estate plan, depending on which you have. So
Right,
ownership's gonna pass that way, and your prenup is not gonna necessarily control that unless they're coordinated. So.
right,
So
exactly.
that is why people like us have to work together
Right.
to make sure that, our
Right.
clients are taken care of in that way. So
Exactly.
Barbara, we could talk about this all day, and I would love to. But I hope everyone, this has given you a little bit of a flavor of how your estate plan is important, and your family law attorney is also an important person in your life if you're getting married and you think a prenuptial agreement is important, or if you're getting divorced and you need a little help there, or getting remarried, and I would encourage you, if they're not doing it already, to make sure that those two attorneys in your life are talking to each other and sharing information so that everything can be coordinated and your plan can work the way you hope it will. So Barbara, thank you so much.
Yeah.
And thanks to everybody for watching. If you like our videos, please feel free to like them on YouTube, subscribe to our YouTube channel, and give us a call if we can help you in any way. Or if you're looking for Barbara's information, if you need her help, we're happy to provide that to you as well. Take care, everybody. Have a great day. Thanks.